Okay, good afternoon and welcome to the Licensing Subcommittee of today, the 23rd of March 2017. This meeting was scheduled to start at 2 p.m. We were notified by the applicant they were running 5 minutes late, so the subcommittee agreed to delay the start until 10 past, and I have to report that the applicant is still not here. So we will carry on and do the business as on the agenda and hope that the applicant does turn up. I will start off with my chairman's announcements. I welcome you all to those attending this meeting and also to those live. I know people like the woman Hazel Grace who contacted me this week are watching live, so good afternoon to you all. Okay, and I believe is this the applicant? Please, sir, sit down. We are now live online as well, so if you want to take your seat, we'll continue with the notices. The details of the business to be considered today is shown on the agenda, copies of which are available, and is also accessible online under the live broadcast. For those of you in the room intending to speak, please know you may well be filmed, but you will be recorded at all times. And so those of you in the room, you may wish to know that the camera is angled away from the public gallery, not that there's anyone in the public gallery at the moment. A reminder to anyone speaking today that your voice will only be heard when the red light is in front of you. This is a tip for my councillor colleagues especially, because I know they have some very good asides and they perhaps want to press the button first. And I note they indicate already they wish to speak and they will do later. Fire alarm. We're not expecting a fire drill, so if the alarm does go off, please accept that it is a real fire alarm and you will have to leave the building. The fire exits are situated at both doors, to my left and to my right. There's a big sign that says fire exit, and that is the way that you can escape the building, and we assemble quite nicely at the front of the building for licensing outside the Slug and Lettuce. Now, we'll move on to the agenda as we have in front of us, but just before we do that, I'm conscious people have just walked into the room, so I'll introduce myself. I am chairman of this meeting. I'm Councillor Dominic Gillam. The other councillors making decisions today is on the far right is Councillor Lynn Allen, and then we have Councillor David Yarrow. Also assisting me today, I have from Democratic Services a gentleman called Neil Fraser. Now, Neil will be taking minutes. I noticed that his pen is in hand, but he's not writing down. He'll be making minutes of today's meeting. And then I have a legal advisor, Nicole Cameron, who makes sure that the decisions we make are just and correct. We also have from our licence authority, we have one of our new officers. And Jeannie, you're very welcome. Thank you for your agenda today, Jeannie Mukherjee. And I also see that we have from our responsible authorities, Mr. Ian Means. Now, I understand you've just walked into the room. Catch your breath. We won't take into consideration your tardiness at all when we make a decision. But what I will ask you to do, sir, is to press the button when I press mine off. Indicate your name, please, and who you are, where you're from.
Working. Thank you. My name is Robert Botkai. I'm a solicitor representing MRH. If I could just please apologise. We followed all sorts of signs and sat-nav systems. We ended up in a car park miles away and then did several loops and then struggled to find main reception.
Far too much detail, sir. Just your name and address is what I asked for.
I'm very sorry. And to my right, catching her breath, is Nicola.
So they can just, do you switch your button off?
But I was going to
just press your button. They can do it. They can speak, I'm sure. Press your button. Thank you.
Hi, I'm Nicola Law, and I'm from Malthurst Petroleum.
Just press. No, that's it.
Milan Patel from Malthurst Petroleum.
Excellent. All very welcome here today. Thank you very much indeed. Right, so we move on to the hearing. As I did indicate, this is the subcommittee meeting of Thursday, the 23rd of March. I take the apologies for absence.
No apologies received, Chair.
Good, excellent. Declarations of interest and matters coming before this meeting. No declarations of interest. Okay, I can confirm that all of the agenda items are in part one. And part one, sorry, can you just press your button, please, so that we don't hear your mutterings? Thank you. All items are in part one, which is held in public. If it was in part two, we'd ask members of the public to leave, but we don't have that issue. And I can confirm that all matters have been notified and there's none in advance or urgent. Excellent. And before we go any further, I just want to clarify, does everyone have a copy of the addendum in front of them? Yeah. Yes? You have it as well, sir? Brilliant. Okay. So, we're going to go now to agenda item 5, which is your application for a premises licence. But before we hear from the licence officer, I have a legal statement from our advisor.
So I'm just going to introduce Section 176 of the Licensing Act 2003. I think it's important that members understand what 176 is and the case law that surrounds it. So I'll just introduce it. You will hear from the responsible authorities and from licensing authority and also from the applicant, but I feel that it's important and Chairman wanted me to just give you a background. Might bring my close actually. So Section 176 of the Licensing Act 2003 prohibits the sale of or supply of alcohol from premises used primarily as a garage. Premises are used as a garage if they are selling petrol or diesel. The applicant has confirmed that the premises shall sell petrol and diesel. However, the premises shall include a convenience store. The word primarily is not defined in, in the Act. However, the concept of a premises being primarily used as a garage has been before the courts. Arguments have concerned whether primary use is an enforcement rather than an eligibility issue when deciding upon an application for premises licence. It has been made clear that the subcommittee has representations before them that questions the sale of alcohol from what may well become a garage for the purposes of Section 176. The premises is currently under construction, and therefore the applicant is unable to provide whether the garage or the convenience store shall be the primary use, although the applicant believes that it shall be the convenience store. There are two main methods of primary use. So it can either be the number of transactions, i.e. how many sales for fuel and how many sales for goods are sold within the convenience store, or it can be the transactional value of those transactions. There has been debate over which of the two methods is most appropriate, and this matter has been before the courts. And I'll just quickly summarise some of the main cases. So in the first case I'll discuss is the Green and Justices for Inner London area, which was in 1993. Okay. If the transactional values of transactions are used, then duty and VAT must be stripped out of all sales. It's 1993 in terms of the rep. The second case is the Liverpool Crown Court ex parte Goodwin, and the question must be, what is the intensity of use by customers? In relation to the most recent case, and its shortest name is known as Merco, and I'm sure you have the full citation, in 2010, it is a matter for each licensing authority to decide whether it will decide primary use on the basis of numbers of transaction or evidence of turnover. The case further confirms that where there is insufficient information about primary use, the authority may defer the matter to another date until the question is resolved to their satisfaction. The approach generally adopted by the court since Merco 2010 seems to have been the focus on the numbers and whether the premises are used more intensely by customers for sales of fuel than for the sale of other products such as food products. I consider that the members have the following options: refuse to grant the premises licence, defer the hearing to another date until the applicant is able to provide information that confirms primary use, insert a condition to the premise licence relating to Section 176, or decide primary use is an enforcement rather than eligibility issue and grant the premises licence without a condition relating to 176. Members are aware that their decision must be based on all written and oral evidence with the intention of upholding the licensing objectives. The applicant is unable to provide information about primary use and has therefore suggested a condition to address the lack of information and to overcome the representation. I understand that there has been an attempt to agree a condition and potentially an agreement. In general, the use of an appropriate condition is a sensible way to avoid deferral of a matter that has the potential to overcome the representations. It shall be a matter for members to decide whether the condition is appropriate based on all the evidence presented, orally and in written form, with always the intention of upholding the licensing objectives. You will hear from all parties as to their position. You must make your decision based on that. This is an outline of the law.
Okay, at this point we're not going to debate that, but I'm sure later on you may well feel that you need to have some clarification going on. That's fine. We'll now have the presentation from the licensing officer.
Thank you, Chairman.
No, just to be clarified, we do have an order of proceedings. Okay, if you've got a copy of that here. Okay, so we'll go through that, and at your point, you will be called, and then you can speak. Unfortunately, this is a subcommittee. I'm the chairman of that. If you wish to speak at your point, you can, but at other points, it's not open to debate.
Good afternoon, Chairman, committee members, and a very good afternoon to all of you here. We are considering a new premises license application received in respect of a convenience store, which will be located within a petrol station forecourt. The premises will be known as MRH East Court, and this will be at High Road East Court, Pinner, HA5 2ET. The applicant is named as Malthurst Petroleum Limited, and the law firm acting on behalf of the applicant is Winkworth Sherwood LLP. This application is for a license to sell alcohol 24 hours a day, 7 days a week, and also to include the sale of late-night refreshments. The site where the premises is located is currently under construction. The plan submitted with the initial application, that's Appendix 2A on page 26 of the report, indicates that the entire premises is being sought for the sale of alcohol and the provision of late-night refreshments. There was an additional condition of a night pay window put in by the applicant's solicitor following the submission of the application, and so an updated plan was requested by the licensing authority showing the position of this hatch. A brief note on the plan has been outlined in item 2 of the addendum, and the plan itself identifying the position of the night pay window is appended as Appendix 7 in the addendum. Any sales between the hours of 2300 and 0500 hours will be made through this hatch. The entrance door to the shop will be closed between these hours. Kindly note that the applicant does not wish this newly submitted plan to form part of the license. I'll move on to the representations now. So the application is put before the committee due to the receipt of 3 representations, one of which was withdrawn last evening. 2 of the representations have been made by 2 interested parties living in the vicinity of the premises. However, neither of them are attending the hearing this afternoon. The representations were put in due to concerns under the Licensing Act objectives, and all representations were received within the consultation period. The representations by the 2 interested parties can be viewed in Appendix 3B in pages 33 to 34 of the pack. About the 3rd representation, this was initially put in by the licensing authority acting as the responsible authority relating to Section 176 of the Act, which we have already heard from Nicole. However, last evening, the licensing authority has reached an agreement with the applicant's solicitor on this particular condition and has since withdrawn its representation. But this is still open to members to consider with the intention to uphold the licensing objectives. I have mentioned this in item 3 of the addendum, and there is the email from the applicant's solicitor confirming this, which is appended as Appendix 8. The area in which the premises is situated has an off-license store within 100 meters, which is currently licensed till 2300 hours from Monday to Saturday and till 22:30 hours on Sundays. There's one public house also within 100 meters, which is licensed till midnight on weekdays and till 100 hours at weekends. I've indicated these on a site map displayed in Appendix 4 on page 35 of the report. And because there have been amendments at a later stage, so the addendum mainly consists of further clarifications and amendments on the report, on different sections of the report. My recommendation, I would invite the committee to determine the application in whether to grant, refuse, or amend the application as applied for. Thank you for your consideration.
I'm sure there will be points of clarification at this point. So just to go, Mr. Bodkai, we do have a point here where you'll see where we have a discussion, and that's the point where you'll be allowed to ask questions of the legal team. I hope you accept that. But at this point, just to clarify, in your presentation, you stated that the applicant doesn't want this map to be considered as part of the application, or just part of the application regarding cameras. Can you clarify?
Because the updated plan also shows the positions of the CCTV cameras, and the plan's regulations does not say it's necessary to provide the positions of the...
Okay, so therefore we do not have then a area showing us where the night pay will be if we're not allowed to consider this as part of the pack. Is that correct?
It does show the night pay window, which is marked in
I know,
red.
but you just said we're not allowed to consider this as part of the application. So a part of the application in front of us,
Yes,
we do not have...
that's correct.
Okay, that's what I wanted to hear. Councillor Allen. Thank you, that's what I wanted to hear. Thank you, Rashid. As following the agenda, we'll now move to the applicant or stroke licence holder, and I believe Mr. Bodkai, is that the right way of saying it, sir? Mr. Bodkai. Mr. Bodkai, I believe you'll be speaking. So if you want to press the button.
Thank you. Just some preliminary points. You do have the plan in front of you. What I said in correspondence to your licensing officer was that the additional plan wouldn't form part of the licence. Doesn't form part of the application as such, but it's provided for your information. So we're perfectly happy for you to see the plan. That's why it's part of the papers. So we were asked to show where the night pay window is. That's shown coloured red. And we were also asked to produce a plan showing where the CCTV cameras are going to be. So we've indicated those on the plan, but we never include CCTV cameras on our licence plans for the obvious reason that for security or whatever reason in the future, we may wish to move a camera, and we wouldn't want to have to come back for a major variation application every time we wanted to move a camera. That would be a complete nonsense. So the plan's regulations don't require us to put to show the cameras. We used to have the same problem with shelves of bananas when people were marking on the commodities on the licence plans. Then technically, if you move the bananas to another part of the store, you'd have to apply for a variation. The licence plan is part of the licence. Anything that changes on the licence, you have to come back for a variation, minor or major.
It will be a minor, not a major variation.
No, not necessarily. If we moved a camera...
I'll seek clarification from my office about that, but I believe it would have been a minor. But okay, carry on.
With respect, it would be a decision for the licensing officers to take at that time. So you wouldn't be able to determine today whether that was a minor or a major variation. We would put the application in, and the licensing officer would have discretion whether to deal with it as a minor, but may decide to do it as a major. If I can move on from that, so you do have the plan in front of you, and you can consider that. It's just that we would ask that it not be attached to the licence. So it's there for information purposes. It's perfectly normal procedure. Then, I've got a number of things that I want to talk to you about, but on Section 176, I'm very concerned that we're dealing with this at all. In your legal advisor's opening, she mentioned that there is a representation that raises the question of Section 176. Well, that's been withdrawn, so I wonder whether that statement was written before the representation was withdrawn.
If you read Section 182, I believe it's paragraph 9, what it says is that you have to give 24 hours notice of a withdrawal. So actually, before the members, we don't have that formal withdrawal yet, hence why my advice was the way it was. We will hear from the responsible authorities, and I'm sure they will withdraw, but as it stands at the moment, it's not formally withdrawn.
Well, perhaps Mr Means could be opportunity then, because he has written in to withdraw his representation, I understand. So if Mr Means has withdrawn his representation, it will save a great deal of time today if Section 176 isn't going to be considered. I can talk to you for an hour on Section 176.
I won't allow an hour, trust me. Please continue with your application process. But we don't need to hear an hour. We just need you to get the salient points. You've got some guidance here. I'm sure, Mr Bodkai, you've been in front of many committees previously.
I have.
Okay, so just tell us about your application and evidence how you can prove primary use when the shop is not already open.
Right. Well, so are you saying that the application... Right. So you're saying there is a live representation concerning primary use? You are? Even though it was withdrawn yesterday?
Yes, it's a yes, because it's not been formally withdrawn, and
Okay.
under, I think it's paragraph 9.32 of the Section 182 guidance, it says that 24 hours must be given.
Okay.
I'm sure there will be a withdrawal, but the members it's still open for the members to consider the condition that's been agreed. We're at hearing, we're not at application stage, so the chairman and the committee members can consider Section 176 and the condition that's been agreed. They will, of course, listen to your concerns, they will listen to your representations, but they can go on to consider whether the condition fulfills to their satisfaction.
Okay. I'll give you a short version. If I can do a short version, and then if you could indicate that you're satisfied or not. If you're not satisfied, would you then give me the opportunity to go into a little bit more?
Again, you've been on these meetings before previously. I'm sure you understand the process. You're here now to just give us the outline of the application that we are going to consider. After that point, we will hear from the responsible authorities. Then there will be a discussion. It clearly says in our agenda what we will do. So at that point, if you feel you need to interject again, we will welcome that. Okay. But just currently now, I want to hear about your application and how it can uphold the 4 licence objectives. That's what I want to hear from you now, sir.
Thank you. Well, I will touch on Section 176 as it appears to be on the table. Section 176 states that premises premises that have a licence, the licence doesn't take effect if the premises are primarily used as a garage. It's not a pre-test of getting a licence. That's how it differs from the 1964 Act. So in the 1964 Act, before the justices, we had to apply and persuade the justices, the magistrates, that the primary use was not that of a garage. That changed when the 2003 Act came in 2005. There was then quite a considerable confusion because some applicants were still putting in data as part of their application process. We didn't. So from 2005, certainly my firm, and we've dealt with about 2,000 petrol station alcohol licences, we don't put data in as part of the application process. And that's because it becomes a nonsense, it becomes very confusing, and Section 176 doesn't require us to do so. If you were to look at Section 17 of the Act, that tells you what an applicant must do in order to get a licence. We've got to put in an application, we've got to put in a plan, and we've got to serve it on the authorities. Nowhere there does it say that we have to prove primary use. So there's nothing in Section 17. Section 18 then says what you as a licensing authority and committee must do in order to determine an application. And there is nothing there about Section 176 or primary use. So we follow the procedure in Section 17 and the licensing authority follows the procedure in Section 18. The Section 176 kicks in once the licence is granted. And you're perfectly entitled to ask us, well, once this licence is granted, how will you monitor it to make sure that it's not disqualified under Section 176? Are you with me so far?
Yeah, of course, continue.
Yeah. So, Malthurst, MRH, has 278 petrol stations that are licensed to sell alcohol. So all of these have got premises licences, and they monitor the primary use of all of those stores. As indicated briefly by your legal advisor, there is no actual test for primary use that's been established by the courts. There have been the 3 cases that she referred to very briefly. I can talk about them in much more detail. It's not quite as Mrs. Cameron referred to. Sadly, I was around for both the Timothy Green case in 1994 and the Goodwin case in 1998 and then the Mirko case. I can talk to you in great detail about those cases if you wish me to do so. There's no need because subsequent to the Mirko decision, I could talk to you about the specifics of that case, but it's very different to this case. I've been involved in discussions with the Home Office about the guidance because the Section 182 guidance from the government was causing confusion for applicants and licensing authorities about what to do with applications for petrol stations. And that's why the guidance was rewritten. It was rewritten with my assistance, and we now have paragraphs 521, 22 and 23. And 5.22 says it's for the licensing authority, based on the licensing objectives, to decide whether it's appropriate for the premises to be granted a licence, taking into account the documents and information listed in 17.3 and 17.4. So it's made quite clear in the guidance now that primary use is something that follows the grant of the licence, and it's not an issue for the application process itself. So let's say if you were, to give you an example, if you were to refuse the application because you're not satisfied on primary use, there would then be a judicial review, well, possibly an appeal, but probably a judicial review, because you don't have the remit to refuse an application on primary use. You can only refuse the application based on the matters set out in section 18. So that was clarified by the... So that was... So if legal advice has been given, it's helpful if it's open. That would be normal protocol. I don't...
Mr. Buckeye, you can carry on. I'm hearing what you're saying. I'm very, very conscious of what you're saying. I'm just clarifying the pieces of paper that we have in front of us about that. I don't feel I have to share everything with you that I discussed with my legal advisor. Okay? The information that I share with her would be classed as privileged. I'm sure you'd understand that.
Okay, thank
Do
you.
I accept that, Mr. Buckeye?
I'm not going to...
You're not going to answer. Okay, thank you.
So section 176 kicks in once the licence has been granted. So the matters to be determined by you today are the representations which have been made by the residents, certainly once Mr. Means has withdrawn his representation. So we were in discussion with your officers about a condition that would go on the licence, which is perfectly sensible, and the condition would then set out the obligation to monitor the primary use of the premises, which we would have to do anyway. So I've looked at the Malthurst licences, and we have 17 licences with conditions on, and I sent the condition, the standard wording, to your officers, which initially wasn't agreed, but then in discussion with Mr. Means yesterday, we amended that standard wording, and we have agreed the wording which is in your addendum, and that is that the licence holder, Sir Malthurst, will monitor the primary use. This is page, it's not got a page number, Appendix 8. The licence holder will monitor the primary use of the premises, and if transaction data demonstrates that the premises are excluded, pursuant to section 176, the sale of alcohol will cease until such time as the data demonstrates that the premises are not so excluded. The data will show how customers use the premises, comparing the number of fuel-only transactions with non-fuel transactions. Such data will be maintained on a 6-monthly basis and will be available on request to the Police and Licensing Authority. This condition will fall away in the event that Section 176 is repealed. So that if I can explain the transaction data, just going back to the first case that Mrs. Cameron mentioned, she mentioned the case of Timothy Green. What the Timothy Green case actually said was that if you're looking at one set of figures on the fuel side, you need to compare similar figures on the shop side. So the accident in Timothy Green was that one side of the equation had duty and the other didn't. So it didn't say the test is turnover. What it did say is that the test that you must apply the same test for one side of the equation and the other. Following Timothy Green, there were lots of petrol stations licences granted, 1994, and then in 1998, Mr. Goodwin applied for a licence in Southport, and he used transaction data, and the judge in that case ruled that it didn't matter what the premises looked like or what they were called or known as in the locality, so it didn't matter if they're known as the garage. It's the intensity of use that's important, and the intensity of use was the transaction data, and that's what we're saying here, that we will monitor the transaction data. And the reason we don't look at turnover when we're looking at primary use is that you then get into an extremely difficult and complex calculation, stripping out duty from the fuel side, stripping out duty from the tobacco side, trying to work out what part of a national lottery ticket is duty, but it's not duty, it's a tax effectively. Certainly when years ago that we last had to even debate this, but it was 95p went to the national lottery and 5p to retailer. It gets hopelessly complicated, and then if the Chancellor does a U-turn and changes the tax one morning, then that changes how the premises are going to be used. So it's an absolute mess if you start looking at turnover, whether it's net or gross. So all of the stores that we've dealt with since, certainly since 1998 have only looked at the transaction data, the intensity of use, as per the Goodwin case, and all of our clients are advised that it doesn't matter when, but that all times during the life of the licence, they have to ensure that the primary use of the premises are not that of a garage. And that's the beauty of it. That's why it's so different to the old system. Perhaps that's not always understood. Under the old system, it's a one-off moment. So we'd go into court, and we'd have an accountant, we'd have an expert who blind the magistrates with data, lots of spreadsheets and information and pie charts, and there were people making careers out of this. And then we come out of court, and we do a hop skip out of court, and there was no obligation on us ever to look at the data again. So once it was a one-off moment to establish primary use under the 1964 Act. The good part of the new Act, because it was changed, is that the primary use applies throughout the life of the licence. So Nikki, who's responsible for all of MRH's licences, she makes sure that there is a system to monitor the primary use of all of their stores. And if the primary use is shown by that transaction data to be that of a garage, that's the sale of fuel or the sale or maintenance of motor vehicles, then they stop selling alcohol. And there have been times when they have suspended the sales of alcohol because of primary use. Now, the comfort that you've got today is that this is going to be a large store. So it was a small petrol station, not licensed, but this is going to be, it's going from a 16 square metre to a 122 square metre store. It's going to be a significant small supermarket. It is inconceivable that the primary use of this site will be that of a garage. It's simply not possible. If it was a garage, heads would roll because they've invested X number of hundreds of £1,000s in building the site, and they're doing that for the shop and not so much for the fuel. We could produce projected data for you. Again, that would be a nonsense. We don't need to. It's not part of the it's not under Section 17, and it's not under Section 18. But it would, if it's of any comfort to you, this store will clear the primary use hurdle very, very comfortably. The analogy, if you like, is the BP Marks & Spencer stores, and you've got two of those in your area, I believe. Neither of those stores have got a primary use condition on. So I have been asking your licensing officer for copies of any other licenses in your area that have got primary use conditions. She hasn't replied, so I've done my own research, and certainly the two BP petrol stations that are licensed in your area do not have primary use conditions. But I can tell you that BP Marks & Spencer stores, and this is going to be similar to BP Marks & Spencer, when I've last looked at the data for those stores, similar size, it's something like 70-80% shop and 20-30% fuel. So it's way ahead. It's not going to be a small petrol station which is close to the wire. The primary use of these premises will not be a garage. So we've proposed the condition. It has been agreed by your licensing officer. It would be very helpful for me to know now that you're satisfied on this particular point, and then I can move on to the application and the representations that are outstanding.
I think I already said that you do a presentation, we hear from responsible authorities, and then we have we'll have a discussion.
Well, in which case
I'm not going to change the agenda, just to your request, sir. Thank you for that. I assume, is that the end of your...
Well, no, it's not, because I haven't dealt with
the
representation. Thank you. So this is an application for a new licence. We are seeking a licence for 24 hours, late night refreshment between 11 p.m. and 5 a.m. Late night refreshments in one of these stores is very, very limited. It's generally so that a hot cup of coffee can be served during the night. It's unlikely that there will be any significant hot food. It tends not to be controversial. We've never had any issue with late night refreshment being served at one of our stores. The alcohol will, the night pay window condition was agreed with the police. The police are your experts on crime and disorder, and they have agreed the application based on there being the night pay window. So at 11 o'clock at the latest, we would close the doors, and any sales would be made through the night pay window. Your own guidance does state in paragraph 21.5 that shops will generally be able to sell alcohol to match their trading hours. So that's paragraph 21.5. Restrictions may be applied, for example, where representations are made indicating that particular premises or patrons are linked to disorder and or disturbance. So you would expect, if that were the case, that the police would have brought that to your attention, but they haven't done so. The government's own guidance also states that shops should generally be allowed to sell alcohol to match their trading hours unless there are good reasons to restrict those hours. And again, it's stated that they would expect the police to bring those issues to your attention. They're not sitting on the fence here today. They have looked at the application, they have negotiated a condition with us, and they're not objecting to it. So the application is within your policy, and it's within the Section 182 guidance. You have no representations from any of the responsible authorities, as that's police, police, I'll come on to licensing in a moment, environmental health officer, planning, trading standards, fire officer responsible for protecting children from harm. None of those officers is objecting to the application today. We have the application from your licensing officer, which has been withdrawn, so it's a technicality as to whether you accept that that is withdrawn in time for today's proceedings. The store is not in a community of impact zone, which means that the reversal of the burden of proof does not happen here. So you would need to be satisfied based on the representations that the grant of the licence would be contrary to the licensing objectives. We have two resident objections. Mr. Ronald van der Hoogen is concerned that if the licence is granted, it may result in antisocial behaviour. That doesn't satisfy the test. That's not sufficient without evidence that there is currently antisocial behaviour or a real risk of antisocial behaviour by the grant of this licence. That statement in itself is not sufficient, particularly when the police are not objecting. And again, I can point you to the paragraph in the guidance where it's quite clear that the police are your experts on crime and disorder. He's also concerned about parking. Well, this application can't be a rerun of a planning application. There has been a planning application for this site. I have provided the information as requested by your licensing officer. There will be 5 car parking spaces and 1 for staff on the site, but the parking issue would have been dealt with under planning. And then the other objector is concerned about the possibility of increased litter and questions why there should be a 24-hour operation. And again, that's reopening the planning application, which has been dealt with. We have planning permission for a 24-hour operation. We have planning application for 24 hours. So again, that's not to be reopened today. For information, the designated premise supervisor named on the licence is Nikki, but that will change before the store opens to sell alcohol, and we will have the local manager who will be the DPS. I think I've covered primary use, but I'm very happy to talk to you in more detail about that. You've got the condition which has been agreed with the licensing officer, and I understand that now that is withdrawn. So you have 2 representations, and that is why we have the hearing today. So it's to consider the representations raised by the residents, and if I can answer any questions about the operation of the store, about MRH, about our experience elsewhere, or about the particulars of the area, I'm very happy to do so. But that is the application. Thank you.
Okay. Indeed. Any points of clarification at this point? No. Questions? Okay. We'll move them down to as per the agenda in the sub. We have a representation from the responsible authority. Ian.
Thank you, Mr. Chairman, councillors. Yes, going back a little bit in history, this application is obviously a new build, and as such, when it first came in, the local authority considered whether they were able, in the initial period, to assess the ability of the premises to decide on primary use. It is a large premises, and the consideration was that it would probably be as large as the BP has been mentioned, and thus fall within primary use. But it wasn't mentioned in the application, and so the licensing authority sought to qualify the application by means of a condition. And the conditions that we first sought were sent in our representation, and since that original letter, there has been some discussion between myself through Ginny, mediating as the law permits. Should an agreement be met before a hearing, then the condition is normally added to the licence, and the committee would not hear that condition at all. It would be something which would be added to the licence. Late last night, because we were looking for a little bit more from the condition that was offered, Mr. Botkai and his team offered us. We agreed a condition, and basically the bits that were put in to the original condition that Mr. Botkai had offered was around what we see in the Mirko case, and it really is about footfall and takes it away from the type of figures that you'd have to use if you're working out the price of all the goods against petrol. To my mind, and therefore to the licensing authority's decision, is that we were happy to accept a condition that included footfall. It's a simplistic way of dealing with matters. It has been verified by the court in Mirko, and with this added a couple of sentences on the condition as has been read out, we felt that it was acceptable. It was only the timing, really, Chairman, that has brought me to this desk and not back there where I was intending to sit today. Because of Section 9 of the 182 guidance, you have an ability, and I have not the ability, to withdraw this matter for me to be sitting here and explaining what's gone on. So it is the case that I would otherwise have withdrawn this matter. I'm accepting the condition that the applicants have offered. I think it's something which we can move forward with. I think it covers the gap that was made in the original application. And if I can assist the committee any further with that, I'm happy to answer any questions on it.
Yep, there will be a couple, Ian. Just to clarify, does the local authority, i.e. Hillingdon, have an adopted policy regarding primary, to make a decision regarding on primary use? And have we adopted policy, so do we take footfall or do we look at turnover?
As far as I know, Mr. Chairman, we have. It's not mentioned in the policy particularly.
We do not have one. I know it's free, and Justice Cranton states in the Mirko case that we can do that. We've heard from both sides the same paragraph that we've all got in front of us. I just want to know if Hillingdon itself had something in it to hand.
Not as far as I know.
Okay. You just said you were happy with the application in front of you. We have heard already from the applicant and also from the licensing officer regarding the night pay window. We don't have that as part of the plans that we look at because they're not allowing that to be part of the application process. They said it's allowed to be considered but not part of the application process. So are we happy with that as an authority, or do we want to see that in a map?
This is a little bit outside of what I was looking at. Can I ask, is the night pay window part of a condition that we have in place?
Yeah, I'm just saying, would we like to see that on an actual plan? Because the plan that they've shown it, they've requested it, is not part of the application.
We're happy to mark.
Sorry, please, I will call you out, Mr. Botkai. Now,
I'm trying to help.
No, well, fine. When it indicate you wish to speak, please switch your light off. I'm just getting some clarification points. There will be a discussion, sir, later on. I just want to clarify some things. So please don't interject again. I would request you do not interject again, sir. Thank you. So just to clarify, from yourself, as the Hillingdon local authority, would you expect to see that window in the plan?
I don't think it's something which comes in many applications. However, if the applicants wish to put it in the plan at this stage, the plan goes forward as part of the licence and it would be inclusive to the licence.
That's what I wanted to hear from you. Thank you. Councillor Allen, is there anything you want to question at this point?
You mentioned that you're responsible in this law for judging petrol stations' primary use.
Sorry, Councillor Allen, we're just clarifying with Councillor Ian Means about issues on his presentation. That's all we're doing. We haven't moved to the sub-discussion yet.
I apologise, I'll step back.
So there is no more further points of clarification from Ian Means? Members? No. Okay. All right. Okay. So now we do move to the discussion. It usually goes through the chairman. Please, if you do wish to indicate, raise your arm. I will call your name, and we will just have some clarification. The first one, Mr. Botkai, in your presentation, just a couple of things I want to clarify with you, if you could, please, sir. You said it would be an absolute mess if you had to measure on net or gross turnover. Surely gross turnover would be very easy to measure, because it would just be the sales figures without any duties taken into consideration.
Yes, you would immediately disqualify 3,500 petrol stations around the country from...
This is correct. I understand that fully,
yep.
But You just said it was an absolute mess. It'll be very. Your actual words were it'll be an absolute mess to measure on net or gross. On gross turnover, it will be very easy.
It would be very easy, but it would be wrong. Because
that's your opinion?
It would be wrong in law, because it wouldn't determine the primary use of the premises. It would determine the primary sales. It wouldn't determine the primary use, and Section 176 refers to primary use.
Also, Mr. Bockhart, you did state that you were concerned that other large forecourt convenience stores, shall we call them, in the borough do not have a condition. Just to clarify, as you probably know, each applicant is judged on its own merits. And so the conditions that may be attached to one licence are to that licence only. There's no standardised conditions here, so that's probably why that's the case. You also said, sir, that antisocial behaviour is a planning issue and shouldn't be considered. You said antisocial behaviour has been dealt with by the planning commission process.
I said parking has been dealt with. Antisocial behaviour would be for the police to raise. I didn't say the antisocial behaviour has nothing to do with planning. Parking would be the planning, and the 24-hour operation of the premises is planning. So whether the store can open 24 hours is planning, and the parking is planning. I certainly didn't say that antisocial behaviour.
Oh, sorry, because obviously parking and other antisocial behaviour problems will be deemed as public nuisance, which is obviously one of the licensing conditions. For example, if there was an awful lot of parking outside an area which is caused by licensed premises, we could deem it as public nuisance. Just to be fair. Just to be fair. Yeah. Okay, I get what you were saying, but I just want to clarify that bit also. And you also mentioned the police about this night pay window. Have they seen a map with that night pay window on it?
I've had discussions with the police. It's very obvious where the night pay window is, because it's at the window where the cashier stands. So that was the discussion that we had with the police. The night pay window can only be in one place.
Have they seen it? So have they seen a map with a night pay window indicated?
They've seen the map where the cashier stands, so they don't need to see.
They haven't seen a map with a night pay window on it. That's
what I want
to know.
Seen the map. They've seen the plan of the store, and that shows where the cashier
thank you,
is.
Mr. Booker.
There's no other place for the night pay window.
Thank you. Councillor Allen.
Thank you. I'll go back, Ms. Law. You said that you've been responsible for judging primary use. Can I ask how many times you've judged that the shop is not the primary use of the ones you've dealt with?
I couldn't tell you how many. I can tell you that if they don't meet primary use. The figures are assessed, and if they don't meet primary use and they don't meet our tests, then the off licence is removed. We remove the off licence, we refit the store without the alcohol included.
But roughly, can I ask how many?
We assess all of them on a monthly basis, but I couldn't tell you out of the 306 how many we've removed the off licence, but it's been a fair few that we've removed the off licence from.
Go on to the next question. Can I ask, you've evidently done your homework on marketing. Can I ask how many other petrol stations are in the vicinity? Bearing in mind, we're sitting here trying to balance things. I'd like to know if they know how many other petrol stations are in the vicinity.
This is not an application for a petrol station.
No.
Do you mean a convenience store that sells alcohol? Well, do you want to ask that then, Councillor Allen?
It would have helped. Thank you. Can you tell me how many other convenience stores are in that area?
Well, we don't have to demonstrate a need for a license, if that's what you're asking. It's not part of the application process to demonstrate a need for a new license. So I'm not trying to be difficult, but this time.
I've noted.
I would support that finding. He's correct on that. It's not relevant for the decision today.
Councillor Yarrow.
Thank you, Chairman. You said that you had 278 stations that were already approved. And I'm just going to go back really to what Councillor Allen was saying. How many of those have ever had their licence revoked or whatever it is because they don't meet the criteria? You've got 278 that are already approved.
Yes.
How many have not been approved?
none, to my knowledge, have not been approved by licensing committees. But as Nicky's just said, MRH as well. First of all, licensing committees don't look at the primary use in the way that we're trying to do today, because they follow the guidance. But the MRH does monitor the primary use of its stores, and I know that some petrol stations don't, but MRH does. And they, as Nicky was saying, she looks at the data once a month, and if a store is not trading if it is trading primarily as a garage, then they stop. They're told to stop selling alcohol. And there have been a few of those cases, but we don't have the number.
Sorry, can I just clarify? You said you look at the data once a month.
Yes.
Okay.
Can I just ask our legal representative if we are also of the opinion that primary use is not an item that can be used to revoke or refuse an application? That it seems to revolve around two different legal arguments.
It does. I don't agree that it's not a consideration. The representation has been withdrawn, but the condition that's being put forward... So sorry, actually, let me start again. It's been withdrawn, less than 24 hours, and it's for chairman's discretion for the acceptance of that withdrawal. But it is relevant that the responsible authority has withdrawn that representation. What you have before you is a condition to overcome the issue, and I have explained at the beginning that it is a sensible way to overcome Section 176, and that it is something for you to consider. It is for you to consider the condition and agree that condition should be attached. The point that I think was being made is that when you're at application stage, if no relevant representations come in at application stage, you can't amend the condition. So if there was no Section 176 condition, you couldn't amend it to put that on. But you're in a different scenario. You've had a representation, and whilst it's been withdrawn, it was withdrawn with less than 24 hours notice, and you have the ability to consider that condition, and you may decide, based on all the evidence that you hear, that you've read, whether you feel that that condition is appropriate.
Can I just follow that up, just to get my head around the way this is eventually going to be judged, and that is, if somebody goes in and buys a Snickers bar or £50 worth of fuel, are both those given the same weighting?
That's a very good question, and that's precisely why the whole issue of Timothy Green and Goodwin came up. Believe me, I've been in court many, many times before the 2003 Act came, where these arguments were taking place. And actually, it's only because your perception, if I can say that, of the fuel as being a big thing, because you're paying £50 for it against a Snickers bar, which you're paying...
Sorry, there is other chocolate bars available. This is on YouTube, Mr. Bockeye, so can we please just remember that? Thank you.
Funnily enough, I always use the example of a Kit Kat, but we differ on lots of issues, but I'll go with a Snickers bar. So the Snickers bar you think of as a small thing that you're paying £1 for, and the petrol you think of as a big thing because you're paying £50 for. Actually, on the petrol, most of that is going to the government, because 70-80% of the price of fuel is duty, and that's why the whole net turnover argument. So your question is really about net turnover, and that's why we've moved away. Believe me, we had full day court hearings with accountants and trying to work out what went into the equation. The National Lottery pretty much killed us off, and then you've got the ATMs as well. You've got the cash machines. So we said on the one side, well, the turnover from the if you're going to have turnover, then it's the turnover from the cash machine as well. That's a lot of money. So that's why I say it becomes a mess, because you can have £1 million worth of cash going out of a machine. That's huge. You can have a post office in the shop. Is it the post office? People can pay for their gas and electricity in the shops. So it really did become completely unmanageable. And actually, the Goodwin case was all the way back in 1998, which talked about the intensity of use. So if you went into to answer your question, if you went in, you bought a tank of fuel and you bought a Snickers bar, then you'd be neutral, because you'd be one and one. If you just went in and bought fuel, you'd be fuel. If you just bought the Snickers bar, and in the olden days, what used to happen was that we'd have to get the managers or the cashiers to fill in. Nicky, remember this? Stickmen. So for every transaction that was done, we filled in a chart, and then we worked out or we went through the till rolls, bags of till rolls, and we'd work out the use. Thankfully, we've now got these back office systems which are designed to show us how the customers, so the intensity of use, how customers are using the premises, and MRH uses that back office data to ensure that it trades legally.
Councillor Yarrow.
Can I just follow on with it? We've got two situations here. We've got the proof of the pudding is going to be in the eating when you come up with the figures that you will eventually come up with as to which is the primary source of supply. But also we've got it really also applies to the people who are objecting to this application, because there is no past history. And they have nothing to go by, and the proof of the pudding is going to be what actually happens when it opens.
Okay. Right. So the situation. Well, first of all, the two objectors are not objecting on primary use. So the only right. So the only reason we're even talking about primary use is because it was raised by the licensing authority, and I was too slow in agreeing the condition with Mr. Means. Again, it's quite common to agree a condition the day before, or even outside the hearing. It's been done many times, and a committee would accept the withdrawal of a representation, because, frankly, if this matter went to appeal based on a representation which has been withdrawn, it would be a very strange appeal, a very strange appeal. So the representation has been withdrawn. The representation has been withdrawn. It's at the chairman's discretion, which I hope will be exercised reasonably, to accept or not accept the licensing officer's withdrawal of the representation. But because we don't know how that discretion is going to be applied, we are talking about primary use. To answer your question, how will it work in the future? Well, if an officer or if anybody believes that we are primarily a garage, then we are open to prosecution under section 136. I hate to introduce another provision, because you can't prosecute under section 176, but you can prosecute under, you can either review the licence on the basis that the premises are primarily a garage and use section 176, or you prosecute on the basis that the sales of alcohol are not authorised by a proper licence, because the licence has no effect. So that would be the process. It would be a section 136 prosecution. And I'm not trying to blag about what else I've done, but I hope you'll take into account that having dealt with probably 2,000 petrol station applications, and we look after those 2,000 petrol station licences. So that's for BP, for Sainsbury's, for MRH. There's another company called Rontec, and there's lots of independent petrol station owners out there. So we're managing, I'd estimate, about 2,000 petrol stations. I have yet to see a prosecution on primary use, and I have not seen a review of a premises based on primary use. And that's generally because the officers accept that petrol stations selling alcohol is not an issue. Quite rightly, you should be looking at the licensing objectives. So if you believe that this store is likely to result in crime and disorder, public nuisance, public safety, or harming children, then obviously it's for you to decide whether you've got sufficient evidence to refuse the licence. But on petrol versus shop, that would be a matter for the courts if not satisfied with the data. So if your officer was to say to us in 6 months' time, please send us the data, we would do that. Without hesitation, we will send the data. If the officer then says, well, your data is not satisfactory, you're trading illegally, and we continue to trade, then it's open to the officer to prosecute.
Mr. Bockhart, can you just get the agenda pack ready and look at page 26, members, if you could too as well. I'm going to go back to this, my concern over your night pay window. Because this is the application plan that we are looking at. So the application plan we're looking at has no indication where alcohol will be sold.
Again, in line with all the other applications.
Okay, so, sorry. So you're saying the whole store, but then you said that you've then handed this one in, which indicates a different area for alcohol to be sold.
because we were asked to indicate that on a plan, so we've indicated it for information purposes only.
So just to clarify, the CCTV will cover the whole area of the store?
Yes, it does.
But you don't wish to show that by showing the CCTV in the...
Well, for the reason...
I'm just asking you, you don't wish to show... I understand what you said, that you may need to change it in a certain time, but you don't wish to show that in the plans in front of us.
We're happy for you to show you the plans, which we're doing. That's why they're in the paper.
You don't want to be part of the application pack?
Well, we don't think it should be... No,
I'm asking you.
It is part of the application pack. I think we're on semantics here. All we say...
Yeah, I probably am semantics, because I can't see a window. I'm not clear. I know you said that this is not the best drawing. Excuse my planning process. I can see from the office that there's a change in thickness. I mean, I'm supposed to assume that this is glass frontage all the way along then?
Can I suggest that we just go
like that? It doesn't stipulate that at all,
right.
Sir.
Can I just say that we go like that and write night pay window? Night pay window on the licence plan, on the application plan, and we indicate it like that, and then we're all happy.
The condition you said that you didn't want to do that, and now you offer to change it. That's fine.
Because of the CCTV.
Well, I clarified with my officer, and she said...
I know, and I tried...
I did ask that question of her. Sir, please wait a second. And it clearly said that was not to be part of the application pack. I would welcome this map as part of the application pack, and I hear what you're saying about no CCTV to be indicated.
Okay.
Are you wishing to put this as part of the application pack, as part of the addendum process? Yes.
Answer. I did try to interject at precisely the point that your officer... Right, well, if I can clarify, we have no objection, and this is what I was trying to say earlier on, we have no objection to the night pay window being shown on the plan.
Thank you. Councillor Allen, are you clear where it is? Yes. Sorry, Mr. Bocker, a lot of us sit on planning, we're very keen on good drawings and detail, and it may well be the way it's scanned, but even on the pad, it's not the best of plans I've seen in front of me. Okay. Councillor Allen, are you happy where the window is now? You can clearly see on it. Okay. Okay. So what we do now, we do closing remarks, and we do it in the other way. So we go to the obviously just you don't get anything to say at this point. So we go to Ian, if you'd like to sum up as the responsible authority.
Can I just ensure that Ginny has a accurate plan of where that night pay window is going to be before the other hearings? Other than that, Chairman, I've spoken about this condition that we have discussed at length between the applicant and myself, and I am happy that will undertake my concerns under the licensing objectives. I'm happy that to be placed into the licence. Thank you.
Ginny, any points now you want to add?
None, Chairman.
No?
No, thank you.
Okay, Mr. Bocker, all the other applicants, you may at this point sum up, and I mean sum up, please.
So I hope that you're satisfied on section 176, given the agreement that's been reached with your officer, that we have the condition as stated in the addendum on the licence, and we'll work with the officer should there be any requests for data. As for the application itself, under section 17 and section 18, I hope that you're satisfied that there is no evidence whatsoever before you today that the grant of this licence is likely to result in an increase in crime and disorder, public nuisance, public safety, or the protection of children from harm. And on that basis, I would ask you to grant the licence as sought. If you have any questions or if any concerns about conditions, I would ask you to give me the opportunity, please, to readdress you once you have considered the application. Thank you.
Just to clarify, you're right. I mean, the concerns can then be raised later on, and we have a review process. So any concerns raised by residents, if they were to, then they could do a review process. Now we're going to go into our deliberations. So we ask you all to leave the room. Ian will make sure that if you need refreshments or convenience, you can deal with it. I'm sure. Yeah. Thank you.